his tax returns to the public. Is today's decision going to change that?
Not necessarily, Tony, but this is a major defeat for President Trump. He was trying to block the Manhattan District Attorney from getting his tax returns and potentially other financial documents. The District Attorney, Cyrus Vance, was investigating potential hush money payments that the Trump campaign made to some women, including Stormy Daniels. The president argued in the courts very broad-based constitutional issues that presidents were absolutely immune from any criminal prosecution while they were in office. The Supreme Court today rejected that argument, rejected his broad-based arguments with a vote of 7-2. The decision was written by the Chief Justice John Roberts, joined in the judgment by the president's two appointees, Justices Neil Gorsuch and Justice Brett Kavanaugh. Justices Clarence Thomas and Samuel Alito filed a dissent saying that this would harm the presidency because it would allow state grand juries, and there are 2,300 local district attorneys, to conduct political dragnets on a president. But the ruling today means that President Trump's broad arguments are rejected. He can now go back to the court and make specific arguments about why this subpoena to his accounting firm would be onerous, would impede his duties as president to comply with that. That's a difficult argument for the president to make. This grand jury may well get these records. We're waiting now on the opinions in the next case, the House committees that are also seeking his financial documents. That decision is out now. I'm going to look at it.
All right, Jen, we will come back to you then in a moment while you're digesting that decision as it's released. But right now, let's go to Paula Reed at the White House, who's been following along with us. Paula, the president over time has offered a variety of explanations for why he wants to keep his tax returns undercover, including he's under audit. He's also said flatly, none of your business. What's he saying today?
Nothing so far, but he has been on Twitter generally tweeting about presidential harassment, prosecutorial misconduct, and he is not going to be happy about this loss because those tweets that he's already sent out today really mirror the arguments that his personal attorneys have made to defend him in this case. They have argued that the reason that state prosecutors should not be able to subpoena the president's records is because it would open them up potentially to political harassment. So this ruling today, this is, as Jan noted, a loss for the president. He is unlikely to be happy. I have reached out to the president's personal attorneys who have represented him in this case, and we are, of course, waiting comment from the White House, from the president, that they are probably likely waiting on the second case that has to deal with requests from Congress, in the hope that perhaps the president will prevail there, and they can maybe, in some ways, try to frame this as not a complete loss.
Paula, the CBS News polling shows that a slim majority of Americans would like to take a look at President Trump's tax returns, but there's a major partisan split on that. It's a 52% overall, but you can see there 81% of Republicans say they are not interested in seeing President Trump's tax returns. On the other side, 84% of Democrats believe he should release his tax returns. Could you remind us how we got to this moment, this intense partisan split, and now, as we wait a second Supreme Court decision, a big day at the High Court?
The president has gone to great lengths to conceal his tax returns and his financial records really since 2015. And now with the first ruling, there is a chance that voters could get to see some of that information ahead of the election, though Jan notes the president does have some avenues where he can try to continue to block these records from being released. Very important, Tony. If it turns out that he loses both of these cases, it's not the president that turns over these records. It's his accountants and his bankers, and they have said whatever the courts rule, they will comply with this. That's why that second decision is so key. But today, the reason this is really the biggest question for the court this season is that they are looking at whether Congress or state prosecutors can request these documents from a sitting president. Now, the president's lawyers have argued that Congress, which says it's looking into whether the president tried to conceal hush money payments he paid to women who he had affairs with before he went into office, whether they actually had a legitimate reason for doing so. His lawyers said they did not, and they should not be able to get this information.
Yeah, there's the legal question of the subpoenas. The political question goes back to Richard Nixon, who released his return saying that the American public has a right to know if their president pays a fair share, as well as, in that famous phrase, whether or not their president is a crook. Paula, thank you. Let's go back to Jan, who's taken a look at that second decision today. We've got two highly anticipated rulings. Jan, good morning again to you. So what are the justices saying about this second case involving Congress?
All right, Tony, let me just give you some background on this first so it's all clear. The first case was about whether or not a state grand jury could get some of Trump's financial documents and tax returns. This case is the much broader and in many ways more significant case over whether 3 congressional committees that are doing wide investigations into the president, his businesses, Trump-affiliated industries, whether they can not only get his tax returns, but financial documents going back more than a decade. I mean, this was a wide-ranging request for information. And today, the Supreme Court, by the same lineup of justices, 7-2, written by Chief Justice John Roberts, joined by the liberals and the president's 2 new appointees, have ruled that those subpoenas cannot be enforced. So this, in some ways, is a win, a partial win for President Trump, because now they're sending this back to Congress and the lower courts to show that there was a heightened need for this information. The court in this ruling is saying that because they are seeking so much information against a sitting president, that Congress, when it wants that kind of information, has to show a heightened need for it, that there are serious separation of powers concerns at issue. What was Congress's legitimate legislative purpose in seeking this information? And I got to say, Tony, none of this is really that surprising. If you listen to the arguments, the liberal justices were very concerned about this as well, and you see them joining the Chief Justice's opinion today. As Justice Breyer said in that argument, I've got to be concerned if we've got a Senator McCarthy doing an investigation of, say, a future Franklin Delano Roosevelt or a Harry Truman. The court's ruling today, of course, would apply to the next president, whether that's President Trump or it's going to be President Biden. So all the justices were very concerned about this wide kind of separation of powers issue, and that Congress was going to be able to do some kind of political dragnet on a sitting president. So now this will go back. Congress is going to have to do more to show it needs these documents and why it needs them, the specific legislative need for them, why it's important that they know this while they're passing laws. So that today is a win for Trump. It's going to delay it. Finally, I've got to say this is a win for the Supreme Court. The justices did not want the court to be injected into the election. The fact that 7 justices have joined now to make these rulings, liberals, conservatives, Trump appointees. This case today, this one anyway, may be a win for court. The first for Trump, the first one I think is a loss, but overall it's a win for the Supreme Court that they were able to come together and release this kind of decision.
I think that's very important to note, Jan. So in the first case, the president's lawyers did not prevail on the argument that the president is immune from a state criminal case from providing evidence there. But on the second case, Congress is going to have to do a better job if it wants these records in the near term. Do you have a sense of what the timetable will be for when these cases go back to a lower court, when there could be another decision point?
It could happen very quickly, and you could imagine that House Democrats are going to be motivated to make it happen very quickly. They can file emergency requests that this has to be done now, immediately. But I think that's going to be very difficult for us to get a final decision, certainly in the congressional cases, before November. Of course, they can continue their investigations after the president is either out of office or reelected. The question is, are voters going to know this information before December? I think that's going to be a difficult stretch. But also remember, just because Congress and the grand jury was getting this information, if they were going to anyway, didn't necessarily mean it would become public. Grand juries are supposed to be confidential. That's not supposed to leak. So I guess we'll just have to wait and see on the time frame. But it's not looking likely that we're going to see this anytime soon.
Yeah, that's a very important point. And quick from a legal perspective is not necessarily quick from the general public's perspective. We've got an election in another 117 days by my count. So, Jan, thank you very much. Our coverage will continue on our 24-hour streaming network, CBSN. You can watch it at cbsnews.com or on our CBS News app. And there will be more to come on your local news on this CBS station. And tonight, of course, on the CBS Evening News with Norah O'Donnell. Many of you will now return to CBS This Morning. This has been a CBS News special report. I'm Tony DeCopel, CBS News, New York.